everyone, and we are the local group. My name is LALLAINE F. Barrios, and today we're going to talk about the E-Commerce Act or the Electronic Commerce Act, Republic Act number 8792. So, aside from the personal consumer transaction, RA 8792 also applies to a contract of carriage of goods in the transport of the goods to the buyer and the recipient. So when we say the carriage of goods, it is stated by the law as the movement of the goods by the land, sea, or air. This includes packaging, storage, transport, unloading, and distribution. So the carriage is often the final step in the contract of the sale of the goods. The shipper is often a freight vendor, and the final consignee is also the recipient of the freight. Risk and the title to the goods will be often changed during the contract of the carriage. Carriage of goods can be unimodal or multimodal. Unimodal or the single mode of transport refers to a carriage of goods when only one mode of the transport is used. So while multimodal or the combined transport, it refers to a situation where a combination of the methods is used. So the inclusion under this section or the section 25 will be discussed by my team.
Good day everyone, I am ROMEL GELITO. So for today, I will share to you my learnings about Section 25, actions related to contract of carriage of goods without derogating from the provision of Part 2 of this law. So this chapter applies to any action in connection with or in pursuance of a contract of carriage of goods, including but not limited to the following. So letter A is furnishing the marks, number, quantity, or weight of goods. Second is stating or declaring the nature or value of goods. Third is issuing a receipt for goods. And last is confirming that goods have been loaded. So the leading marks necessary for the identification of the goods as the same are furnished in writing by the shipper before the loading of such good starts, provided such marks are stamped or otherwise shown clearly upon the goods if uncovered or on the cases or coverings in which such goods are contained, in such manner as should ordinarily remain legible until the end of the voyage. So either the number of packages or pieces or the quantity or weight, as the case may be, as furnished in writing by the shipper. So the apparent order and condition of the goods, provided that no carrier, master, or agent of the carrier shall be bound to state or show in the bill of lading any marks, number, quantity, or weight which he has reasonable ground for suspecting not accurately to represent the goods actually received or which he has had no reasonable means of checking. So, if it is made fraudulent or negligently, such representations may form the basis of an action in tort against the carrier by third parties which suffer in reliance on them.
Good day everyone, I am Hazel here to continue the report on the actions related to the contracts of carriage of goods. Now we also have notifying a person of the terms and conditions of the contract and giving instructions to a carrier. When entering into a contract for the carriage of goods, it is important to ensure that the basic and formal requirements are contained in the contract. It is also important to have the date and time of issue of the contract and to clarify that all parties have been informed on the conditions prior to the departure of the goods. This is in cases that incidents happen during the transport. Among common carriers, they are usually evidenced by the terms and conditions on the reverse of a ticket or a carriage document. Sometimes this is also why the bill of lading exists. It is, in the first place, an acknowledgement that the carrier has received the goods, or either merely an evidence of the contract of the carriage, or in some jurisdiction, it is regarded as the contract itself. We also have claiming delivery of goods, authorizing release of goods, and giving notice of loss of or damage to goods. It is important for the contract to capture the place where the goods are taken over by the carrier's place of departure, and the final destination of the goods. The planned date of arrival should be also included, including the references of the recipient, such as the name and the exact address. A notification of the shipment's arrival is usually sent to the notified party whose address is in the shipping document, usually the buyer or the importer. As a receipt, the bill of lading is also prima facie evidence that the goods have been delivered. That will be all for this report.
Good day, everyone. My name is ROMEL de la CRUZ. I am the last reporter in this group, and I will discuss the remaining topic in relation to carriage of goods. To continue, letter D, giving any other notice or statement in connection with the performance of the contract. So we all know that notice are a requirements in many contracts, and specific clauses are drafted where the parties to a contract are obligated to notify one another in certain circumstances. The carrier must serve a notice where the goods are received, drawing attention to the need for declaration. So for example, giving the scale of extra charges or shipping fee. Letter E, undertaking to deliver goods to a named person or a person authorized to claim delivery. It means that there is a guarantee or assurance that the carrier must deliver the goods safely and is liable for any delay caused by his negligence. Letter F, granting, acquiring, renouncing, surrendering, transferring, or negotiating rights in goods. And letter G, acquiring or transferring rights and obligations under the contract. This too implies that the carrier has rights and obligations depending on the agreement on the contract.